everyone, and thank you for joining us for our webinar tonight on Torres v. Madrid, our review of the case with Jeff Green. So I'm going to introduce
Hello, everyone. Jeff
Green first. So Jeff is an experienced advocate who has argued 5 cases before the Supreme Court, 2 in one day, which is the most you can argue, and that's pretty unusual. He's the co-founder of Sidley's Supreme Court Pro Bono program. He is the co-director of the Northwestern Law Supreme Court Clinic. And important to today's webinar, he wrote an amicus brief for this case for the National Association of Criminal Defense Lawyers. And what isn't there is he's also a great friend to street law. So many of you may have participated in our programs and the Supreme Court Summer Institute. It's very likely you heard Jeff speak or he trained you to be a lawyer in a moot court. Because he is always happy to help us out when we need him like we do tonight. So I'll turn it over to Jeff to say a couple words.
Thanks so much. I'm so sorry I can't see all of you. I don't yet have a green screen, so my head's going to float a little bit. But I did want you to, feel the moment with the sunset on the Supreme Court behind me. I am a big believer in street law's mission, an even bigger believer in what you all do in terms of teaching. You all are my heroes. And so whenever Kathy asks, she can be confident that, I will be more than happy to participate as long as you'll have me.
Thanks, Jeff. We'll definitely take you up on that. This is how to participate in tonight's webinar. I have a feeling that we all have lots of Zoom webinar experience at this point, but feel obligated to go over it. So a great way to leave a question throughout tonight's webinar is to use the Q&A function. And we're using the upvote function tonight too. So as you go to leave a question, you can glance over the other questions. If someone submitted a question very similar, you can upvote it instead of submitting your question, or if you see a question that interests you, and that will make it come up the queue. You can also use the chat function, and that may be on a bar at the bottom of your screen, or it may be under a more with the 3 ellipses. Please, if you want to just speak to me, Jeff, or Ben Marks, who you can see his picture there. Ben is here as tech support tonight. He's our communications coordinator. You can just send a message to the panelists, or if you want everyone to see it, you can choose panelists and participants. You can also raise your hand if you'd like to ask a verbal question. So we'd like to see who's here today so that we can sort of tailor our presentation to our audience. So Ben is going to launch a poll, but we'd also like you to practice the chat function. And if you'd like to tell us your name and your school and say hi, that would be great. We know that we have a lot of recidivists, people who come back to these things time and again. And it's nice to see some friendly names there and to meet some new people.
I'm guessing all of our teachers are very conversant with the chat function and the hand raising function.
Great, it's great to see some names I recognize and some new names in the chat. Okay, I'm going to share the results of the poll. So hopefully you're seeing the results of the poll. It looks like we have almost completely neck and neck government and law teachers and some history teachers. And I know some of you probably teach both, so you had to make a choice about which one to say you were tonight. So. So to get to tonight's materials, you can just hold your cell phone up to the, oops, my cell phone just disappeared. You can hold your cell phone up to the little QR code. You don't even need a QR reader. It will just do it through your, camera function, and that will take you to the files. This PowerPoint will be one of them. So if you want to repurpose it for student use, you're more than welcome to. And then a Word document that has the links to all of the materials we're going to talk about tonight, so that you don't have to, worry about capturing all the links. That being said, Ben is going to drop links in the chat box if you want to just open them to save them later. So, so he'll be dropping some links, but they'll all also be included in the link that he just dropped right now, that bit.ly. That bit.ly will also be on the very last slide. Okay, so it's the end of a long day, so we're going to start out with a refresher about the Fourth Amendment. I'm sure you probably all have read it many times, and probably some have it memorized. But this case is going to be really centered around the words that are highlighted there. The idea of being secure in your person and protected against unreasonable searches and seizures. So those three highlighted words or phrases, secure in their persons, unreasonable, and seizures, are going to really be what we focus on tonight as far as the Fourth Amendment. So the first word we're going to look at is seizure. So these are the easy answers to that question, and then we're going to get into the nuances later. There are two established categories of seizures. One is based on the application of physical force to a person's body. So you're being handcuffed, you're being subdued. At that point, you've been seized. The second type is a show of authority that causes the person to submit. So if the police say stop police, or in the old police dramas when they would say stop in the name of the law, those things are a show of authority. So in this case, you'll notice that it's contingent on the person actually submitting. So they actually have to stop. That's pretty undisputed. What's going to be in question is if the same holds true for the first one. So that's a little bit of foreshadowing. The other word that we had highlighted was unreasonable. So one of the things we have to look at is what makes a search unreasonable versus reasonable. So one of the things might be, was there a warrant to seize property, a warrant to seize the person or arrest the person? If there is, it's likely reasonable. There are many warrantless searches and seizures as well that you don't need a warrant for. So you've probably taught some of these exceptions, like exigent circumstances, plain view for searches, consent, all those things if a person consents to go with a police officer. Another thing that may make a search unreasonable is the use of force. And I'm not going to say much about this because Jeff's going to talk about it momentarily, but the force needs to be a reasonable response. And so, and if it's not, it can be considered excessive force. And lastly, when we do all of these things in the Fourth Amendment, we have to think about, since unreasonable is the standard in the amendment, we have to think about what would a reasonable person believe as far as this test. So that can be difficult because the reasonable person is fictional. We don't have a person that we name as the reasonable person that we can just, have on speed dial and ask. The court has to decide what would a rational person, given the circumstances, believe about this seizure. So I'm going to turn it over to Jeff to talk about excessive force.
Great, thanks, Kathy. I'm in admiration of how you're able to take an awful lot of Fourth Amendment law and get it into 4 or 5 slides. That's very impressive. So excessive force is what you would assume it would be just by looking at those pair of words. We know that police officers are capable of using force. That's why they carry batons. That's why they carry tasers. That's why they carry guns. The question is, when does it become excessive? And as Kathy said, this fictional person, this fictional reasonable person, is the measuring stick that we use to decide. And so there you see it again, and you'll see it as Kathy previewed a number of times, this reasonableness. And you should hear the justices in the chamber during Fourth Amendment cases. They always say, well, it all comes down to reasonableness. And so the question is, you need to tell me why this was not reasonable. And so when it comes to lethal force, and that's what's at issue in Torres versus Madrid, you know, there had better be a lethal reason for using lethal force. So as we all know, police officers can't club people, they can't tase people, although, you know, that's something of an issue as well. They can't fire at people unless they feel that they are being reasonably threatened. And it is, again, a reasonable person test. What the officer thought, you know, maybe that individual looked like somebody who had attacked them before. Maybe that individual was somebody that they knew in some circumstances, or knew, as I mentioned, to be dangerous. That doesn't matter. What matters is what went on right then and there, and whether that officer, or whether, a reasonable person would think that that officer used reasonable force. Now, Kathy added in the second bullet point, which I want to linger on for a second, and that is police officers may be sued and held liable. Now, there's a lot of barriers, as you might imagine, and we saw one today. You know, you can sue a police officer. A police officer can also be criminally charged, but the grand jury has to agree to return an indictment, and the Louisville, Kentucky grand jury did not return an indictment with respect to the officers that shot Breonna Taylor. But there's other doctrines that we'll talk about, including qualified immunity, that make it harder to sue police officers. But there is a law, and a very important one, called Section 1983, 28 U.S.C. Section 1983, which allows suits for constitutional violations. That's key here. Violations of constitutional rights, quote, under color of state law. And so when police violate your constitutional rights, they are open to a federal lawsuit that will be tried in federal court. And that is important in the dynamics of our government as well, because you know, the typical thinking is states should take care of their state authorities, but when you open the door to federal court, then the officer and the state that is, you know, supporting the officer have to attend or have to defend the case in federal court. I do want to put in a little plug here, and it has nothing to do with any relationship. There is a book, a recent book of 2020, called The Color of Law, which is a nice pun on Section 1983, which talks about these types of cases. It talks about discrimination in housing. It talks about discrimination in enforcement. And if you're looking for a broader discussion of discrimination in our society and the history of it, I strongly recommend that book. The author is Richard Rothstein, who is a professor of law at Stanford University. Sorry for the detour and frolic, Kathy. As we noted, it's constitutional rights. Here, it's the Fourth Amendment, and then, of course, the force must be shown to be excessive.
Great. I'm actually in the middle of that book, so if you had given me the heads up, I could have held your Vanna and, like, you know, displayed it, but it's on my bedstand. So, so qualified immunity. First, before we talk about qualified immunity, I want to make it clear that this case does not challenge qualified immunity. So this doctrine is getting a lot of scrutiny and a lot of press right now because of the Black Lives Matter movement and other social justice movements. The court had at least 6 petitions for certiorari asking them to hear cases specifically challenging the doctrine of qualified immunity this term, and they declined to grant any of those petitions. So this case doesn't directly challenge qualified immunity, but it is integral to this case. So let's talk about what it is, and then we'll talk about why it has to do with Torres v. Madrid. So the idea of qualified immunity is that even when officers have found to be guilty of excessive force, they may still be able to avoid the lawsuit that Jeff talked about by claiming qualified immunity. And what it is I'm going to go back to one more. It is a judicially created doctrine. So that means it's not in the Constitution. There's no federal law that says this exists. It's been decisions from courts over time, really starting in the 60s, that and then ramping up from there, that protect public employees from being held personally responsible or liable and sued for injuries they cause during the normal course of their duties, as long as they didn't knowingly violate clearly established statutory or constitutional rights. And sometimes you'll hear the quote that they're not plainly incompetent or knowingly violate the law. So it comes into this case, and this is a little bit of foreshadowing, because Ms. Torres is going to make a civil rights claim against the officers. And they are going to file a motion for summary judgment based on claiming qualified immunity. And it comes down to what we were talking about before, whether she was seized. The basis of their case for qualified immunity is going to be that since she was not seized, therefore they did not violate a clearly established constitutional right. So those words there, clearly established statutory or constitutional rights, and the definition of seizure is how qualified immunity plays into our case today. Jeff, do you want to add anything to that?
Yeah, if I could just briefly,
Yes,
to clarify too, qualified immunity has not been decided in this case yet, because the trial court judge and the Court of Appeals said there was no constitutional violation in the first place. So first there has to be a constitutional violation, then we look at whether there was qualified immunity. We don't know why the court, I mean, I can guess at reasons why the court denied all the petitions on the qualified immunity doctrine itself. Interestingly, Justice Thomas has filed a number of dissents from denial of review, saying this is a judge-made doctrine. It has no basis in law or the Constitution, as Kathy mentioned, and therefore we should review it and review it carefully. But his colleagues have not joined him in that call for review. And it's things like, you know, the officers came in, they were executing a search warrant, and they stole stuff. They just stole valuable stuff. And they are excused from the lawsuit on the basis of qualified immunity because there is no Supreme Court's case. So, you know, I don't think it's a surprise, but there's no Supreme Court case that says officers may not steal stuff when they execute a search warrant. And so the courts say, well, you know, there's no Supreme Court case. We've got to give you qualified immunity. And that's what's causing the tension and the frustration, frankly.
we already have a submitted question about qualified immunity, so when we get to Q&A, we'll definitely cover that question. Okay, I'm going to review the facts, or maybe you're hearing them for the first time, for the case Torres v. Madrid. And before we talk about this, I want to say that I read both the briefs from Torres and Madrid and Williamson, and many other briefs. And this is very much a she said, they said case. So the facts that are going to be in this very quick timeline are sort of stipulated facts. These are facts that are coming up on both sides that aren't really being debated. But if you have time to read the briefs, they're fascinating. They sound like they're from two different events that happened. So what we do know is that the two officers named in this suit, along with two other officers in plainclothes cars, arrived to serve an arrest warrant on Ms. Jackson. And when they get there, according to the officers' briefs, Ms. Torres is standing outside of the apartment of Ms. Jackson, and she's speaking to a man. When she sees them pull in, she gets in her car and starts the motor. This is at 6:30 in the morning. I think all sides agreed that it was still dark at 6:30 in the morning. This takes place in New Mexico. Ms. Torres claims she thought she was being carjacked. She had gotten in her car, locked the doors, and rolled the windows up. And so she claims she thought she was being carjacked. The officers say that they gave her orders such as, show me your hands, but she says that she didn't hear those orders. She believed she was being carjacked. They were wearing tactical vests, but the tactical vests had small patches on it. And so she said she didn't realize, just saw the dark clothing. So she drove forward in her accounts to flee the carjackers. The officers, one, according to most accounts, one was standing at the front driver's side tire, and one was standing on the driver's side car, but of the car as well, but back further. As she drove away, the officer shot 13 times, striking her twice. That is undisputed, that part of it. After she drove a very short way, she collided with another car. She got out of the car. She asked other bystanders to call 911, but she didn't wait for the police to arrive. She saw a running car. A delivery person was loading a car, so she jumped in that car and stole the running car. She drove over 75 miles to a hospital in another town. She was arrested the next day. She gave a false name at the hospital, but they were able to figure out who she was. The next day, she pled no contest to 3 charges, including evading the police officers, assault on a police officer, and the taking of the car. And then she filed a civil rights complaint against the officers for excessive use of force against Madrid and Williamson. So this is the generic how the cases get to the Supreme Court diagram that we all have in our textbooks and we teach to our students. We know that there is a dual system, both cases that come to the court through the state cases. That's not going to be the case in this instance, and ones that come up through the federal side. So we're going to let Jeff walk you through how this case made it to the court.
Sure. So as I mentioned earlier, the suit would have been originally filed in federal court under Section 1983. And as Kathy said, it was against the 2 officers. You can only sue the officers. You can't sue the municipal police department usually. These suits are brought against individuals. But, of course, the town or the city or village or whatever it is are basically on the hook by virtue of collective bargaining agreements or other employment contracts to defend these officers, and also local laws and state laws to take over the defense of these officers. So it's really Roxanne Torres versus the city in New Mexico or the state of New Mexico. And once the district court said there's no constitutional violation here, I'm dismissing, then it went to the 10th Circuit, which affirmed. Now, okay, that's all well and good, but what caused the court to take it was the fact that other, as Kathy's helpful bubblehead has here, great timing, other courts of appeals had decided it differently, decided the very same question differently. And this is exactly what the Supreme Court does. And very surprisingly, a lot of people don't understand this. The Supreme Court is persistently telling us in various ways that we do not sit to correct errors. So if this had been a case of first impression, and the 10th Circuit, the trial court had ruled the way it did, and the 10th Circuit had ruled the way it did, it is very likely that the Supreme Court would not take this case. they would say there's a lot of facts here that make it, you know, factually unique or sui generis, and we're going to wait and see if other courts divide on this question. Many of you remember a case called Obergefell about the constitutionality of gay marriage. The many courts of appeals had decided that the prohibitions on that were not constitutional, or rather were constitutional, and there wasn't a division. But once one of the Court of Appeals, and it was the Sixth Circuit Court of Appeals, said, you know, we think this prohibition is unconstitutional, that's when the court took the case. So it's very serious for the court. We sit, they say, only to unify the law in the land. And as Kathy knows, there were 4 circuits on the other side. So Kathy, is this one you or me? I forget. Me, okay. So, you know, Torres is an interesting phenomenon, and probably, let's all hope it's a unique one, and we don't go through this again in 2021, going into the fall of 2021. But the court, as this notes, closed. The oral arguments in March and April were not canceled, but adjourned. And the court decided in mid-April, much to a lot of anticipation and excitement, because nobody was quite sure what they were going to do, that they were going to take some of the cases which really needed to be decided this term, like, importantly, the so-called faithless elector case, which involved the Electoral College. And of course, with a big election coming up, the court needed to settle the law in that area. So the court went ahead and said, those kinds of cases we are going to have oral arguments on in March, and the rest of the cases, which aren't so immediate, we're going to postpone to the fall. Now, every once in a while, the court will say, we are going to rehear a case. They did that with Citizens United, famously. We are going to rehear a case next fall because we have additional questions about it. We want additional briefing. But this was, of course, all COVID-driven. The oral arguments are now live. You can listen to them. I think CNN broadcasts them. I think Fox News or Fox Radio broadcasts them away. You can listen to them in real time, which is very exciting for folks that have not been able to go to the court and see what goes on live there. But it's not at all like what happens at the court in real time. As noted here, the attorneys talk to each justice by seniority in turn for 2 minutes. Now, normally, as you've no doubt read, the oral argument is kind of this pell-mell discussion. The justices are interrupting each other, and the general rule is that the senior justices get deference with respect to questions that they want to ask, but by no means is it 2 minutes with one justice. It's often not even 20 seconds with one justice. About 40 to 45 questions get asked in any one advocate's presentation in 30 minutes. So the questions go more than one a minute. Now it's 2 minutes, so you start with the Chief Justice, and then you go to Justice Thomas, and then you would have gone to Justice Ginsburg, and you roll down the line with your 2 minutes with each of the justices. And then there are 2 minutes of uninterrupted time for you to talk to the court at the beginning. Not everybody uses those 2 minutes. They say, I cede my time back to the court. And then, of course, very famously and quite humorously, during one of the court's early oral arguments in May, somebody left their mute button off, and we heard a very loud toilet flush. Now, there have been a lot of strange things that have happened in that chamber. I mean, light bulbs have popped. Protesters have stood up and said, overturn Citizens United. And the justices often get off very, very funny quips when that happens. So one of my favorite is light bulb goes out at the very top of the ceiling over the bench. It kind of goes out with a crack. It was actually there that day. And the Chief Justice is Chief Justice John Roberts then, and it was 2005, so he was brand new. He looks up and he says to the advocate, well, you know, this is a new trick that they play on brand new Chief Justices. And Justice Scalia quips, well, it's Halloween, so happy Halloween. And then the Chief Justice turns back to the advocate and says to the advocate, yeah, you know, we were kind of even more in the dark now than we were, or even more in the dark now than we were before. So can you answer the question? But with the toilet flush, nobody said anything because everybody was on mute. So we lost, and the advocate just rolled right over it. And I think we lost one of the great moments for Supreme Court humor that we could have had. But be that as it may, I'm not a big fan of the telephonic arguments. I realize because, you know, that's, you know, we have a lot of experience. We like to go see the give and take and be a part of the give and take in the pell-mell environment. Lots of people are. I think it's been a good thing for the court because people get to hear it live, but it isn't anything like it was before. So Kathy, that's too much on it. Your excellent presentation of the question presented, which is what we call it, that's the issue to be decided to the court, comes next by the court.
Okay, so the issue in this case is, and again, if you read the two briefs, they actually present two different issues. So this is my sort of amalgamation of both those issues. Of course, the court will decide whichever question it wants. So both sides are bringing a different question. Does the application of lethal force to restrain a suspect constitute a seizure within the meaning of the Fourth Amendment, even if the force does not immediately stop the person or result in physical control or custody of the suspect? So that's the question that they will answer, or one similar to their discretion. Okay, Jeff's going to walk us through the two precedents. And by the way, I will say that there, Jeff, you're on mute, that there are many precedents in this case, and we focused on these two. So certainly if you love precedent, you could pull out others, or you could contact me and I can pull them out for you.
Terry stands for the important proposition that not all police encounters are seizures, which, depending on how you look at it, I think that's a fairly police positive view, but you know, it's a law enforcement in priority, and we do want police to be able to say to citizens, can I ask you a question? And certainly we imagine very benign situations like an officer rounding the corner looking for, and it turns to you and says, which way did he go? We wouldn't treat that as a seizure. And so, but the court decided this question way back in 1968 with Terry v. Ohio, and the court said, look, not every stop is a seizure, but officers can, for their own safety, pat you down to make sure you don't have any kind of weapon or you don't have any drugs on you. That was another sort of add-on to the Terry stop. So Terry stops, once that started, were pretty consistently challenged for that reason. So that's not all stops are seizures. And then in Ohio, or in California versus Hodari D, that particular decision stands for the proposition that that if you're not grabbed by physical force, then that's not a seizure either. Now, there's a few, how shall I say, there's a few corollaries to that rule. The chasing is one thing, grabbing is another, right? But also chasing somebody with a weapon is a big deal. And if you use that weapon, then another case, a Tennessee case, it stands for the precedent that if you shoot somebody in the back, that is an excessive use of force. So that's an important codicil to Hodari D. You got to use enough force to restrain him, even if, as it says here, it's ultimately unsuccessful. So officers grab you, you break away, you run away, you get away, that's still an attempted seizure. And we're ready for the next. So We'll run through these very quickly because we want to leave absolutely as much time as we can for your questions. And believe me, your questions can be about this case. I'm happy to answer questions about the Supreme Court as much as I can, and happy to talk about Justice Ginsburg's passing as well, because it's all in our minds. But so, as you might imagine, Torres is saying to the court, look, they not only used force per Hodari D, they used lethal force. This wasn't just a situation where they chased a young man down and he threw the drugs away. This was a situation where it was confused. This, Roxanne Torres thought that she was being carjacked. It's not clear whether these officers made it clear to her who they were so that she might submit to their show of authority. Instead, she was scared. They shot her going away. They shot her 13 times, which I think is something I would emphasize a little bit more than Torres is not shot. They didn't shoot her 13 times. They shot at her 13 times. They struck her twice. And the only question here is whether the fact that she didn't get, or that she didn't stop, she wasn't stopped, she wasn't knocked down by the bullets, she herself didn't stop and turn around and hold her hands up and say, okay, I'm hurt, you got me. The fact that she kept going, that she drove 75 miles, that's the issue in the case, and that's the issue for Torres says, look, you got to have probable cause, and there's other corollaries that we talked about before, with or corollaries to the seizure points and what lines exist. The police cannot draw blood. They cannot take cheek swabs without a warrant. They can't do a whole lot of things without a warrant. And those things are intrusive. And certainly, says Torres, shooting somebody is intrusive.
Yeah, and I was, when we did the Fourth Amendment, and one of the things that I had highlighted was to be secure in their persons. This is where we get to that, because they don't concede, certainly, that she wasn't seized. But in this brief, they kind of say, even if she wasn't seized, there's this whole concept of being secure in your person that is also being abridged. That right is also being abridged, as well as the seizure. And this question about RD, I think you can, we had a question already submitted about what about the fact that Hodari D, it didn't have to do with a gun, and this does have to do with a gun. So maybe you can fold in that original question.
Yeah, so again, it comes down to reasonableness, right? And reasonableness, and as Kathy said, being secure in your person. If the officers shoot at you, that is a very, very strong show of force. And it is an effort to stop you, certainly, especially if they hit you, right? It's a very interesting question in this whole case about, that isn't squarely presented here, but this is the way the Supreme Court thinks. Well, what happens if she just got shot at, but didn't get hit? Is that a seizure? Is that such a show of force? Is that it amounts to a seizure? Is that something that, even though they didn't hit her, made her insecure in her person in violation of the Fourth Amendment? So Hodari D doesn't directly answer the question, given that, he ultimately got stopped and she didn't, and was able to drive 75 miles an hour, or 75 miles to a hospital. And as they noted, the intrusion here is part of it.
Where it mentions that her arm was temporarily paralyzed, that I think that is in dispute, that fact. That's why I didn't make my list of undisputed facts, that she claims that her arm was temporarily paralyzed, and that is part of her argument, that if part of the definition for seizure is that there is a restraint on movement, the paralyzing of her arm restrained her movement. So it meets that definition. Okay.
Yeah, and to be honest with you, I think sometimes this gets to be a little bit of, you'll forgive me, a little bit of angels dancing on the head of pins, right? Really, the fact of the matter is, police shot at her, bullets entered her body. She was certainly no longer secure in her person, but is that enough to affect a seizure if she's not stopped? I do think, as I mentioned, some of the more interesting questions are, what happens if you don't get hit and your arm doesn't get paralyzed? So, what in the world, you might imagine, do officers Madrid and Williams have to say in their own defense? And the argument is basically this: we weren't unreasonable in using our weapons in the situation, as Kathy said, with respect to the facts. There's the disputed facts. The officers are there by the car. Was she trying to shoot them? I think we would all agree that if we were in a narrow alley with as an officer with our back against the wall, and that car was charging down the alley, the officers would have every right to respond to that deadly threat by using their pistols or their guns. So the officers are trying to make it more like the alleyway situation and less like they're standing a ways away from the car and shooting into it. So that's argument number one for them. Argument number two is really just the flip side, to say we never got custody, possession, or control. Those three words are very, very important. Yes, we shot at her. We were reasonable in doing so, but we did not stop her. This is Hodari D, except for she got away. Hodari D, the difference is Hodari D was stopped. The difference here is that she wasn't stopped. How can you have a seizure if she wasn't actually seized? So they're using a very basic and not irrational and very common sense interpretation or construction of the word seizure.
Yes, and both sides Hodari D extensively in their briefs, both sides.
Mm-hmm. And this business about whether she felt free to leave or not, this brings in a whole nother doctrine about whether somebody is in custody or not. That I think that the respondents here, as we call them, to be very polite, if I were Torres's counsel, we would very politely refer to them as our friends on the other side of the podium. Well, our friends on the other side of the podium here are trying to say, well, she wasn't in custody. Custody is a whole different legal doctrine that has to do with whether or not if you're interrogated, you have to be given your Miranda rights, and you don't feel free to leave, right? So if you feel free to leave and you're interrogated, you're asked questions, but you nonetheless answer them, that is not a Miranda violation. You have to be in custody, but that is different than the seizure question that we have now. So I don't think that argument is going to get a whole lot of play.
So we're not really here tonight to talk about teaching these cases, more the content of these cases, but I will mention that in the materials, there are some links to teaching about these cases. One of them is to a classifying arguments activity, and those arguments that you saw Jeff and I just talk about and put up on the screen, there's an activity where you can have your students read those in no particular order and try to figure out, did they help Torres or did they help Madrid? And also in the materials, you'll find a link to our at-home learning page, which gives you some idea for how to take these activities and adapt them to online learning if you're doing online learning. So that's my quick commercial before we go to Q&A, just for some other materials that we have and some ways to actually teach the cases, including suggestions for doing moot courts and mini moot courts and judicial opinion writing and many other kinds of activities. Okay, so we are to the Q&A section, and we would love to take some of your questions. So it looks like the Q&A is open, but we do have some already submitted questions, and we also have some questions in chat. So let me take a question, which is whether Congress can fix the qualified immunity problem. If they can't fix this, who can?
The answer to that is they most certainly could. And what will happen if one of those qualified immunity cases is ultimately granted, and the Supreme Court were to say, we find this an unmoored or unsupported legal doctrine. They're basically, right across the street. If you just walked out the doors of the Supreme Court and you kept walking, you'd run right into the United States Congress. You just got to cross one street. They would basically be sending the issue across the street to the legislature. And that may be where it belongs. That may be what they ultimately say. I don't know, but my guess is that any Congress, whoever the administration is probably going to do something to respond to a decision like that by the United States Supreme Court. State legislatures already have some protections in place as well. But again, these are federal lawsuits, so Congress has got to do something about the federal lawsuits.
Great. So some of the other questions submitted when people registered were, what do you believe will be the short-term and long-term effects of ending qualified immunity?
Yeah, I think we just addressed them. I mean, certainly it would, in the very short term, it's going to cause a lot of suits to go farther than they normally would in the legal process, but they're going to get fixed pretty quickly, or there's going to be a legislative fix pretty quickly.
Okay, sorry, I was writing something in the chat. One of the other questions is, and I think maybe you touched on this earlier, but we'll do it directly. When are officers allowed to use deadly force, and why is the standard more lenient than for civilians?
Officers are allowed to use deadly force when they have a reasonable belief that their lives are in danger, or someone else's life is in danger. Now, with respect to civilians, I did a little bit of research on this. With respect to civilians, the answer is different, but it's different because there is a higher bar for what constitutes a lethal threat. In other words, officers can use lethal force, and I suppose tasing can be, lethal on certain occasions too, but they can use it when they can't control the suspect and they don't know whether that suspect is going to do something harmful to someone else, right? They can club somebody in the same sort of situation. They can club protesters in order to get control of a particular situation. So officers get more leeway when it comes to what constitutes the scope of the threat that they can respond to. Civilians basically have to be shot at before they can use their own gun to shoot at someone else. Or someone else has to be, if they're defending another, that someone has to be in mortal peril is the phrase that gets used. Frankly, that higher bar applied to civilians makes some sense to me because we put our officers in harm's way, and we want our officers to react to situations in ways that will protect all of us. I'm not so sure that that's true of every one of my fellow citizens. I would like to say that it were, but right now I'd like to leave the policing to the officers, so I'll give them a little leeway on it.
So one of the questions I thought for sure would be asked, but it hasn't, so I'll ask it because I'm curious what your answer is going to be. And that is, presumably it will be an 8-member court in October when this case is argued. So, so what do you think that means for this case? And for those people who might not know, what would happen if there was a 4-4 tie in this case, then what would be the result?
Sure. It almost certainly will be an 8-member court. One interesting fact about Supreme Court history is that the shortest time from nomination by the President to confirmation by the Senate was 43 days, and that record belongs to Ruth Bader Ginsburg herself. Even at 43 days, given the fact that this argument is going to take place in October, that's not going to be enough time. So for sure, this argument will take place with 8 members of the court. While it's not written anywhere or it's not required anywhere, new members of the court typically do not vote in cases in which they have not sat to hear oral argument. So existing members of the court, if they get sick, as you all may remember, Chief Justice Rehnquist was very sick for a long time, but nonetheless voted on decisions because he was already a member of the court. But new justices won't do that. So my guess is this, my prediction would be this is going to be decided by an eight-member court. And remember that, as we're all getting reminded of consistently these days, the court didn't have 9 justices for about a year and a half recently after Justice Scalia died. So that the court's used to operating with 8 members. This court is for sure. We could go for a long time about the 8-member court and what that means for the country and why the court itself doesn't like it. But nonetheless, when they have to, and this is one of the have-tos. What happens if they tie 4-4? Then an order comes out from the Supreme Court that says that the decision by the 10th Circuit Court of Appeals in this case is affirmed by an equally divided court. So in other words, it's if it never really went to the Supreme Court to begin with, and the court the court just simply says, the 10th Circuit decision stands. So if there's a 4-4 tie here, Roxanne Torres loses, and the 10th Circuit case becomes law, or it becomes law again. When the court granted review, it was no longer law, but if the court says it stands again because it's evenly divided, then it becomes law again. And so there would still be this division of authority, and we would imagine that at some point the court would decide the question. Because remember, way back, Kathy showed us that there were at least 3 circuits that went the other way and said this is a seizure. The 10th Circuit would have law that would say it's not a seizure. That's the kind of split of authority that the Supreme Court ultimately takes up. Now, the court has an option. The court could say that we are going to, and this is the option I would guess that they would exercise this term. With respect to votes that are equally divided, we are going to reschedule oral argument for later in the year after the new justice is sworn in. Now, that's a little bit risky for the court's reputation because that means they have to kind of publicly recognize that a new justice is going to decide the law. And it all becomes very vivid to us, the power that this new justice has. But frankly, I'd rather that, the decision gets answered by the court rather than, we wait for another day.
Okay, there are 2 questions. Maybe you could have really quick answers because we're at time to pretty much close down Q&A. But the first is, if qualified immunity is thrown out by the court, would the legislative fix likely be more or less permissive of officer conduct than the qualified immunity doctrine has been? And the other one, which maybe you can fold in, is what system would the country resort to if major cities defunded their police departments? I think these are both kind of political questions and not particularly Supreme Court questions. So these might be more opinion than based on this case specifically.
Well, I mean, you and I are from Washington, and offering opinions is a profession around here, right? So I would say the answer to the first question is it would be the same. And the reason why I say that is that there are other laws that Congress knows very well about, including the Anti-Terrorism and Effective Death Penalty Act, which reads a lot like the qualified immunity doctrine. It says there has to be a Supreme Court precedent on point. So my guess is it would be the same. As to defunding the police, you know, I mean, your guess is as good as mine. I do think it would be interesting because, you know, and just as a, you know, an exercise of imagination, if that were to happen, then would there be citizens arrests? And if there were citizens arrests under posse comitatus laws, would that open those individuals to constitutional suits? And would they not be subject to qualified immunity in that particular situation? Certainly, you know, it would present a whole host of interesting questions, but you know, your guess is as good as mine as to whether that's ever going to happen.
So we wanted to do one more quick poll if Ben has it ready. And that is who should win the Supreme Court case, and this case, Torres or Madrid, and who will win the Supreme Court case, knowing that this could be two different things. So Ben has put that poll up. We'll give it a couple more seconds. Torres came out for a fast lead, but the lead is going back and, well, it's diminishing a little bit. Okay, we won't spend much time on this because I don't want to keep you after class. There we go. So you can see those results, right? Torres wins the who should the Supreme Court decide for. And Ben, do you want to put up the who will?
Mm.
Okay, it looks like it's slowed down, Ben. Do you want to publish those? Okay, so we had the opposite results from who we think that Torres, as a group, that Torres should win, and that Madrid will win. So, so you all know the court well enough to know that we're not going to get a quick answer on this. We're probably looking at least 3 months after the case is argued. It could be June. We certainly don't know. So we'll be all watching it, I'm sure. Okay, so just a couple more things before we go. This case is part of a bigger program that we do called SCOTUS in the Classroom, where we pick cases from throughout the term that we feel are of high interest to students, are accessible to students, are things that come up in a lot of standards. So like Fourth Amendment comes up in everybody's standards. And we take those and we write case summaries at about a 10th grade level. And then we put information up on a part of our website called SCOTUS in the Classroom that gives you links to the briefs, the case summary, in this case, the classifying arguments activity. Once the case is decided, the decision will be there, links to the oral arguments. So it's sort of your one-stop shop for cases that are in the news. We don't do every case. Not every case really works for this. We also try to pick cases that are good to moot, that have good arguments that students can kind of sink their teeth into, and not too many issues. So last year, the cases that we did were the two Title VII employment cases, the LGBTQ employment discrimination cases. We did the two faithless elector cases. Jeff mentioned them earlier, Shafalo v. Washington and Colorado v. Baca. We also did a case that kind of fizzled, but you know, we don't know, we don't have a crystal ball. The New York State Rifle and Pistol Association v. City of New York ended up being mooted, although that's kind of an interesting idea to teach our students that sometimes cases don't ever come to a decision. And then the Louisiana abortion law case. Those were the cases we did last year. So we'll pick other cases this year throughout the year, and we'll highlight them and make sure we have materials for you. I mentioned this earlier, but we have a whole page on our website as well that helps you with ideas about how to take sort of classic street law strategies and use them for at-home learning. A great way to figure out what we're doing and which cases we're following and all those kind of things is to follow us on social media. It's probably how you heard about this, so I'm probably preaching to the choir. And or to sign up for our educator newsletter. You can go to our landing page and scroll down to the bottom to the teal bar is an easy way to do that. Or there is a link as well to be able to do that. It's a good way to know when we're doing webinars, things like that. My last plug in my last 30 seconds is that there hopefully will be a 2021 Supreme Court Summer Institute. It's 6 days of intensive learning about the Supreme Court and several visits to the Supreme Court. Hopefully the world goes back to normal and we can do this the way we like to do it. Applications are going to be available on the first Monday in October, which is the day the court opens. We like to commemorate that with opening our application window, and they'll be due March 15th. So please think about applying if you haven't already been. And of course, we'd like to thank Jeff Green for giving so generously of his time. And thank you all for coming. I know that you put in a long day of teaching, and we really appreciate the fact that you stuck around and spent your evening with us. So thank you, everyone.